Bam! Welcome, everybody. Welcome to this episode of The Branca Show. I am, of course, attorney Andrew Branca, your host, your legal expert on all matters, including today, defamation suits. Defamation suits. Kash Patel bringing a $250 million suit against the Atlantic publication. That's what we're going to talk about today. Let's see, just making sure Rumble is cooperating. It looks like it might be. Let's see. I can't tell. Yes, it is. All right. Everybody's here. That's awesome. So, FBI Director Kash Patel has filed a $250 million defamation lawsuit against the publication The Atlantic over a hit piece packed with explosive claims of excessive drinking, missed meetings, a security team unable to wake him, having to get door breaching gear from the FBI, supposedly, and it's sourced entirely by anonymous officials hiding behind the reporter's promise of confidentiality. Or we're told there are sources. Nobody's named. There's no documentation. There's no emails. There's no memos. There's no logs. There's no photographs, except for one. I'll share that with you in a moment. The article cites more than 24 people, grants all of them anonymity, names exactly 0 of them, not one person willing to put their name behind what they purportedly told and the journalist. Now, if the story's true and Patel is the disaster they're describing, you'd think at least 1 or 2 dozen people, 1 or 2 of those 2 dozen people, would stand up and say so publicly. Don't they care about their country? Instead, we get a wall of shadows. Shadows and hit piece journalism. Now, I do want to be straight with you about what Patel is actually up against, because lawsuits, defamation lawsuits brought by public figures are very difficult, very difficult. You have to prove all the normal elements of defamation, that the statement made about you, published about you, was false, that it was published, it was written or spoken to other people, that it caused damages. And then if you're a public figure, you have to prove that the statement was made with actual malice, including reckless disregard for the truth. That's from the New York Times versus Sullivan Supreme Court decision. And in practice, it's a brutally high bar. Has killed more defamation suits by public figures against media organizations than anything else. It leaves these organizations pretty much free to lie about public figures as much as they want, if that burden can't be overcome, and it generally can't. And of course, there are other extra legal burdens that Kash Patel will have to overcome here as well, given the political nature of the jurisdiction and the judiciary in which this lawsuit will be carried out. So, well, we got a Rumble rant right away. Yeah, let me pull this up. From the always generous Gito463, $10, says, missed the live show yesterday due to work, but wanted to let you know the locals did stream as I watched it this morning. Good. I had a little glitch with locals yesterday. It wasn't clear to me that it was working. So we got the Rumble rant in before any super chats. That's not common, YouTube community. Usually you guys are on the ball. So let's take a look at what we're dealing with here. And it really is, of course, just contemptible. Here's the Atlantic article. I'm not going to read the whole article. First of all, I'm not interested in reading propaganda. But also, it looks like I'd have to pay to read it. And I'm not giving the Atlantic any money. But the first couple paragraphs are available here. The FBI director is MIA, they say. He's MIA, missing in action. Subheadline, Kash Patel has alarmed colleagues with episodes of excessive drinking and unexplained absences, claims journalist Sarah Fitzpatrick, the same journalist, by the way, who wrote that now Supreme Court Justice Brett Kavanaugh used to routinely drug women in order to commit predations upon them. I guess that proved to be true, did it? How about that? What happened to those claims? They just disappeared once Kavanaugh was confirmed to the Supreme Court. So Fitzpatrick writes here, on Friday, April 10th, as FBI Director Kash Patel was preparing to leave work for the weekend, he struggled to log on to an internal computer system. He quickly became convinced he had been locked out, and he panicked, frantically calling aides and allies to announce that he had been fired by the White House. According to 9 people familiar with his outreach, 2 of those people described his behavior as a freak out. Look how subjective all this is. It's amazing. He became convinced. How would you know? That he had been locked out, and he panicked. He panicked, frantically calling aides and allies. Some aides and allies, if they're leaking to a journalist, to announce he'd been fired by the White House. Have any of us not been able to log into a computer system and we just assumed we were fired? I couldn't sign into Locals yesterday. According to 9 unnamed people familiar with his outrage, 2 of these people described his behavior as a freak out. I'm sure that wasn't planted. Would you say that was a freak out? Oh, yeah. That's a good way to describe it. Fitzpatrick continues, Patel oversees an agency that employs roughly 38,000 people, including many who are trained to investigate and verify information that can be presented under oath in a court of law. A very wordy way of saying he's the director of the FBI. News of his emotional outburst ricocheted through the Bureau, whether it's true or not, prompting chatter among officials. Well, you can't. People in the workplace are sharing gossip. And in some corners of the building, expressions of relief that they believed he'd been fired. Yeah, because there's a lot of enemies in the FBI for the Trump administration. I talked about that yesterday. The Obama and Biden administrations thoroughly corrupted the FBI, aggressively derailed the careers of the traditional FBI special agents with law enforcement and military backgrounds, and replaced them. Aggressively went out to colleges, university, grad schools, and recruited progressive, fascist, social justice warriors, the purple-haired people, the women who are unmarried and don't have kids. That's what the FBI became. That's what it still is institutionally. And many of those people recruited during the Obama era have now been around long enough to be promoted into FBI management. That's where all this is coming from. Now, interestingly, you see the headline here is FBI director's MIA. They actually changed the headline. The headline was previously, Kash Patel's erratic behavior could cost him his job. Interesting art image there. The sinking of the Atlantic, as opposed, I guess, to the Titanic. I wonder why they changed the headline. Here's a little summary from the Atlantic. Kash Patel's colleagues are alarmed by what they say is erratic behavior and excessive drinking. Erratic behavior and excessive drinking. What's excessive drinking? What's erratic behavior? Behavior you don't like? Sarah Fitzpatrick reports, more than 24 people she spoke with described his management failures and conduct that could harm national security. Now, notice that these 24 people, even assuming she's telling the truth here, these 24 people, she's not saying they described erratic behavior. She's not saying these 24 people described excessive drinking. She's only saying they described his management failures. Well, that's subjective, isn't it? And conduct that could harm national security. Could. Holy cow. Another little piece here. The IT lockout episode is emblematic of Patel's tumultuous tenure as director of the FBI. He is erratic, suspicious of others, and prone to jumping to conclusions before he has necessary evidence. Okay? These are all completely subjective characterizations. This is all completely different than saying this guy's blackout drunk every night. He's MIA. No one's able to find him. He's missing meetings. Those things would be quantitative and verifiable and subject to disproof. But what's erratic? Erratic to who? So Should he not be suspicious? He's inherited directorship of an FBI that's politically opposed to him and the Trump administration generally. He's got good reason to be suspicious. Prone to jumping to conclusions before he has necessary evidence. Whose judgment is that? Who says he doesn't have necessary evidence? He thinks he has the necessary evidence. That's why he's coming to a conclusion. That someone else disagrees is just an opinion. According to more than 24 people I interviewed, Sarah Fitzpatrick now, about Patel's conduct, including current and former FBI officials. So former FBI officials, they're not even in the Bureau anymore. They're not willing to put their name on any of this? Staff at law enforcement and intelligence agencies, doesn't even say they're law enforcement or intelligence officers. They're just staff, like secretaries? Secretaries that work at law enforcement and intelligence agencies? Hospitality industry workers, they're not willing to put their name on this? What is Patel going to fire them from their hospitality job? Members of Congress aren't willing to put their names on any of this? Political operatives? Well, of course they don't want to. Lobbyists and former advisors, fired people who might have a gripe against Patel. And this is the one piece of evidence that I see repeatedly shown, the only one, a photograph of Kash Patel chugging a beer in the locker room of the U.S. hockey team after they won the gold medal in the Olympics. Oh my God, the guy's clearly out of control. You can't have a celebration of an athletic victory. That would be wrong. And then his lawyer sent a letter to the Atlantic, letting them know that what they were preparing to publish was false. That puts them on notice. This creates the basis for a claim of reckless disregard, actual malice in a defamation suit. Now, here's Mark Randazza. I know Mark. Mark's a lawyer, does a lot of First Amendment defamation law, far more expert in defamation law than I am. Well aware of how difficult it is for a public figure to win a defamation claim because of the additional burden of having to prove actual malice. This is his take on this lawsuit. He writes, I've seen shockingly stupid defamation claims by public figures who don't seem to have ever heard of New York Times versus Sullivan. This one, the Kash Patel lawsuit, is not shockingly stupid. It's still not the best. And I hate how the lawsuit begins essentially with his resume. Well, of course, the defamation is largely that Kash Patel is incompetent, incapable, because of the claimed erratic behavior, jumping to conclusions, suspicions of others, getting blackout drunk. So it doesn't surprise me that they would put evidence of competence into the filing. But it has some potential, Mark writes, for some of it to get past the actual malice standard, depending on how the facts shake out. So that's the legal breakdown. Mark thinks, okay, this could have traction. It doesn't automatically go into the garbage bin on the legal merits. And then Mark turns to the political dynamics. He writes, but there's a 0% chance that Kash Patel gets a fair trial in that district. This is the federal district courts in the District of Columbia. He's most likely going to pull a judge that won't let him win, which turns out to have been the case, by the way. We'll share the judge's name in a moment. And even if he pulls a judge who can keep their integrity intact, he won't ever find a jury in that town that has the slightest shred of integrity. So the judge will be a problem and the jury will be a problem, right? By the way, there's 15 district trial court federal judges in the District of Columbia, federal district. 15. 5 of them were not born in America. 5, a full third of the federal district trial court judges in the District of Columbia were not born in America. A 6th one is Jeff Boasberg. And there are others that are as bad as Boasberg, as we'll see in just a moment. Mark writes, all of this was stupid, would have been better to spend the money on a PR agency and to mock the reporter. Well, I guess you can do that too, right? And then he's got the decision, the filing here, not the decision, the complaint, the defamation complaint. We're gonna read through it as part of the show today. So this is the judge you got, Judge Emmett Sullivan. Judge Emmett Sullivan was a firebrand January 6th persecutor as a judge. and is completely afflicted with Trump derangement syndrome. So that's not good for Kash Patel's lawsuit. Judge Emmett Sullivan. And by the way, this is all a way, and I don't think John Reese is necessarily hostile to Kash Patel. I don't really know, but pointing out that Judge Emmett Sullivan, a Trump hater, got the Kash Patel lawsuit against the Atlantic, LOL. We all recognize that the District of Columbia court system is corrupt, is politically corrupt, that someone on the right cannot get a fair judge, cannot get a fair jury, cannot get due process of law. And we just write LOL. That's how true it is. And somehow we're supposed to pretend that's not the state of affairs or that's acceptable. As I note here, tell us that the progressive left judiciary in D.C. is biased against Trump without telling us. And John Reese responds to me. He says, this judge, Emmett Sullivan, called Mike Flynn, General Mike Flynn, a traitor in open court, then tried to throw him in jail. Then he refused to dismiss his case after the Department of Justice filed for dismissal. Remember, Mike Flynn took a guilty plea because they were threatening to put his son in prison for years. So they coerced him into taking a guilty plea that later was dismissed because it was without merit. And in my opinion, there ought not be a District of Columbia district courts at all. The entire federal district should not exist. You know, it didn't always exist. D.C. didn't have its own district court judges. When they needed to litigate a case in the District of Columbia, they would simply bring in, randomly selected, a federal district court judge from elsewhere in the country. So they were not embedded. They were not living in D.C. Their kids weren't going to the same schools as the politicians and the lobbyists and all those corruptive influences. They weren't going to the same cocktail parties. They weren't members of the same golf clubs. You can see how being a federal judge within the hyper-politicized environment of the District of Columbia, you would need an unbelievable strength of character not to be politically corrupted in that process, which, of course, is what's happened. It would be far better if we were selecting random judges from where? From Florida or from Texas, or even from Montana. And we're going to talk about Montana in a bit. Montana Supreme Court handed down a crazy. Montana, you think of it as a red state, right? Same with Utah. They've got the cancer too. They've got the blue cancer. The blue cancer. Statement from the Republic. We stand by our reporting on Kash Patel. We will vigorously defend the Atlantic and our journalists against this meritless lawsuit, which, of course, is what you always say. And Alexander Muse, who I share with you a lot, says, well, do you have any evidence? Do you have any actual evidence? And as I note here, everybody is tough as hell when they get a lawsuit filed against them. They talk tough right until they have to walk through that door into that deposition under oath, and be subject to actual questioning by an attorney. And then I had this little exchange with Viva Fry, David. David's, he lives in Florida now. He's a Canadian citizen. He was a lawyer in Canada. I like David. But we had this little exchange, so I thought I'd share it with you. He says, wow, FBI Director Kash actually sued. The most likely way this plays out is that it gets dismissed at the preliminary stage under anti-SLAPP statutes. Anti-SLAPP statutes are intended to facilitate the dismissal of lawsuits brought for political purposes, or on a motion to dismiss under well-established case law that requires actual malice for public figures. And I'm going to disagree with David on his take there, as I'll explain. Then Patel can say I tried to sue, and it never gets to discovery. If they truly believe in their story, it would be very interesting to see the Atlantic proactively not move to dismiss so it gets to discovery. If the text message's information is accurate, truth is the ultimate defense to a defamation suit. For it to be defamation, the statement in question has to be false. If it's true, there is no defamation. This gets dismissed at a later stage, and the Atlantic would get to do one heck of a victory lap. Yeah, there's a lot of speculation there, David. But this one, a motion to dismiss under well-established case law that requires actual malice. So again, Patel has to have a credible basis for alleging that the statements were defamatory, they were false and damaging, that he had some kind of damages, and he has to overcome the barrier of proving actual malice. So either it was done with actual malice or reckless disregard for the truth. But when if the Atlantic were to move in court for this to be dismissed, summarily dismissed at the very start, the legal standard for dismissing a lawsuit is before any discovery happens, is if it's meritless. And the legal standard there would be, well, the judge is supposed to assume, for the purpose of a request of summary dismissal, the judge is supposed to assume that every allegation in the complaint is true. And only after assuming that every allegation in the claim is true, if there's still no lawsuit on the legal merits, then you can summarily dismiss. But you're required to presume, to believe every claim in the allegation to be true in making that analysis. And I just don't think that if, an honest judge does that, how it wouldn't survive a motion for summary dismissal. Because I expect we'll see enough claims in the defamation complaint that, if true, would overcome actual malice, would show reckless disregard. Now, that's just at the preliminary summary dismissal stage. Once you get to the legal merits, the judge doesn't have to presume, a jury doesn't have to presume anything's true. Then it's all up to the finder of fact to decide what's true or not. But at this preliminary stage, summary dismissal, every fact in the complaint is supposed to be presumed to be true. And if that's the case, I think you get past summary dismissal. You get to discovery. Vivo responded to my comment there. I've read the lawsuit. They make as compelling an argument as they can, but the allegations for actual malice effectively amount to not having given them enough time to respond, for Kash Patel to respond. The Atlantic contacted Kash Patel for comment, and they only gave him 2 hours to respond. Obviously, they were unhappy about that. And basically not conducting what sounds more like a criminal investigation than a journalistic one into the veracity of the allegations. Well, no, the legal standard for reckless disregard is someone just can't whisper a rumor in your ear that a person did something horrible and you just publish it. Reckless disregard exists as a standard because you're supposed to vet the information. And if you don't do that, you get to reckless disregard. Knowing the statements were false or having recklessly published them with no reason to believe they were true, or too little reason, inadequate reason. It may come down to sources, but unless the journalist is lying that she has, in fact, upwards of 24 sources, actual malice is a high threshold. Well, of course, the truth is she doesn't say she has 24 sources, right? We saw how she parses all this out, right? Colleagues are alarmed by erratic behavior and excessive drinking. She doesn't say she has 24 people she spoke with who described excessive drinking. And of course, the specificity of language matters here. It matters here. So, got a couple super chats and a Rumble rant before I dive into the actual complaint itself. So let's, oh, by the way, if you folks like this kind of legal stuff, I should mention, after this, we're going to dive into the Department of Justice. That'll be our members-only show today. My buddy Bill Shipley wrote a piece on a Substack about his experience in the Department of Justice. I just described how the FBI became politically captured by the left during the Obama and Biden administrations, basically sidelined all the traditional FBI special agents with a background in law enforcement and military, and replace them, aggressively recruited from, hotbeds of progressive fascist political ideology. Grad students, mostly women without children, women who weren't married, and completely politicized the FBI. Well, the same thing happened. The same thing happened in the Department of Justice. Bill Shipley was a federal prosecutor in the Department of Justice for, I think, 20 years, a very long time. And he lived through this transition. He observed it in the FBI, but he lived through it in the Department of Justice. This happened to him. All the traditional gray-haired, balding, long experienced prosecutors in the Department of Justice, when Obama came in and then Biden did it too, they were all sidelined. They were all encouraged to leave, and they were replaced by recent law school graduates who had often zero litigation experience, but were politically loyal to the progressive fascist left. That's one of the reasons that, Pam Bondi had so much trouble getting stuff done. Is it just because she's incapable? She's never been incapable before. She was a capable Attorney General of Florida. She was capable in private practice. Or is it that, like Kash Patel, made head of the FBI, Pam Bondi was made head of a DOJ, that's been thoroughly politically captured by the left, has cancer, as I say here. So you need to be a member to join us for that. We transition right there from this show when this show wraps up. But it's only 16 cents a day, folks. $5 a month to be a member of this channel. Get double the number of Branca Show content. And this Saturday, only a few days away from now, you may know my day job is criminal defense attorney with an internationally recognized expertise in self-defense law, use of force law, defense of yourself, defense of others, defense of property. A couple times a year, I run a free webinar, free, doesn't cost a penny, that teaches you how to be hard to convict if you're ever compelled to defend yourself, your family, or your property. You may think you know the legal boundaries for defending yourself, but you almost certainly don't. What you think you know is almost certainly wrong. In about 90 minutes, I teach you how to be hard to convict. It's this Saturday, April 25th. It's a live webinar on Zoom, taught by me. So it doesn't cost anything, but you have to register so we can send you the Zoom link. And you register at hardtoconvict.com. Let me put the banner on the bottom of the screen there too. hardtoconvict.com. Free, but you do have to register. And if you can't make it Saturday, the live stream Saturday, noon Eastern time. But if you can't make it Saturday, if you have a conflict, register anyway, because we'll send you a link to the playback of the webinar. And then you can watch it at your convenience afterwards. But you only get the link if you're registered at hardtoconvict.com. So that's what I would encourage you to do, and hang out on Saturday with me, with all of us. And I know there's people in the comments who've attended this webinar before, so feel free to share your experience. I know it was positive because we only ever get positive feedback on the Hard to Convict webinar. DFRWCA, $2. There's supposed to be a $5 minimum. $5 minimum for super chats. Come on. Hey, Branca, 1L finals this week. Love your shows. Yeah, 1L, first year law school, final exams. So the way I was going to say the way they do it in law school, I went to law school a hot minute ago, but the way they did it when I went to law school is you might take a full year course like constitutional law, and there's only 2 exams. There's like a midterm in the winter, and then there's a final at the end. And the midterm counts for like 20% of your grade. The final's 80%. So the final's pretty important. It's pretty decisive. You better get it right. So good luck, man. Good luck. I know what it's like. Psychological projectionist, £2 sterling. It read like bad fiction, the Atlantic article, perhaps because it is bad fiction. It's got the bad fiction vibe, doesn't it? Doesn't it? And another Rumble rant here from the Klaxon, $5. Says, reminds me of that movie Shattered Glass about the reporter who made up all his stories and was disgraced. The problem is the modern left has zero shame. The ends justify the means. Lying is nothing. Yeah, that's right. Lying is nothing. There is no shame there, so there's no reason not to engage in it. Lying, leaking, deception, whatever they need to do to advance their cause. They're true believers. True believers. All right, let me pull up the complaint and we'll jump into that now. Oh, by the way, if you're here and you have not yet subscribed to this channel, don't be mean. Go ahead. Look how close we are to 285,000 subscribers. We're only 82 short, and there's over 1,000 of you here. Even if you're on Rumble or watching on X, hop over to YouTube, The Branca Show. Hit the subscribe button. And when you get to this stream on YouTube, make sure you hit the thumbs up button too. That's the single most important variable that YouTube uses to put our content in front of more people, especially people who've not seen it before, new eyeballs. we have what? We have on YouTube, we have 600 people watching and 185 of you have hit the thumbs up. Come on, guys. If you're here watching the show, you must like it. Go ahead and hit the thumbs up. That would be greatly appreciated. And let's get 82 of you to subscribe on YouTube and roll that odometer over to 285. That would be just awesome. Okay, now the actual complaint. Let's see what Kash Patel's lawyers have to say. Pull it over here. Grab my red pen. Kash Patel versus The Atlantic Monthly Group, and journalist Sarah Fitzpatrick. Kash Patel, director of the FBI, brings this lawsuit to hold defendants, The Atlantic and staff writer Sarah Fitzpatrick, accountable for a sweeping, malicious and defamatory hit piece published on April 17th. Defendants are, of course, free to criticize the leadership of the FBI, but they crossed the legal line by publishing an article replete with false and obviously fabricated allegations designed to destroy Director Patel's reputation and drive him from office. Indeed, so-called journalist Fitzpatrick could not get a single person to go on the record in defense of these outrageous allegations, even former FBI, even hospitality workers. Instead, relying entirely on anonymous sources she knew to be both highly partisan with an axe to grind and also not in a position to know the facts. Defendants published the article with actual malice, despite being expressly warned hours before publication that the central allegations were categorically false. Despite having abundant publicly available information contradicting those allegations, despite obvious and fatal defects in their own sourcing, despite the Atlantic's well-documented, long-running editorial animus toward Director Patel, despite a request for additional time to respond that defendants refused to honor, and despite deliberately structuring the pre-publication process to avoid receiving information that would refute their narrative. The defendants, Atlantic and Sarah Fitzpatrick, cannot evade responsibility for their malicious lies by hiding behind sham sources. The parties, Kash Patel, FBI, the Atlantic publication, and Sarah Fitzpatrick. And of course, all these people are in D.C., right? Kash is in D.C., Atlantic is in D.C., Sarah Fitzpatrick is in D.C. That's why this is the venue. Jurisdiction venue, this court has subject matter jurisdiction. The defendants are subject to the jurisdiction in D.C. because they all live there. Director Patel and his FBI, and the FBI under his leadership. So I'm not going to read through all this. It's him tooting his own horn. The FBI has done a lot of good work. And the reason he's doing this, maybe it's partly to toot his own horn. He does like to talk about the statistic, Patel, when he's interviewed, I've noticed. But the main allegations of the article, the Atlantic article, are that he's incompetent, that he's a danger to national security, that he's incapable of doing the job properly. So this stuff is relevant in a defamation suit against a allegedly false claim of incapability. Clearly, he's not incapable, the argument goes, if he's managed to do all these things. I do notice that the FBI, he likes to take credit for crime going down generally. Of course, the FBI doesn't enforce general criminal laws, right? They're not your local police department. The fact that crime is going down at the local level doesn't tend to have much to do with the FBI. Nevertheless, Patel's lawyers write, these results have coincided with a publicly reported historic decrease in violent crime. Yeah, okay. And align with the White House's own statement provided to defendants before publication that crime across the country has plummeted to the lowest level in more than 100 years, and many high-profile criminals have been put behind bars. Like, I don't know the extent to which the FBI can really claim credit for this, but clearly he specified a bunch of other stuff that the FBI is involved in. Espionage, cybercrime, drugs, child defenses. The FBI is involved in all of that, and especially counterterrorism. The FBI has a huge counterterrorism function. The Atlantic has for months pursued a demonstrable editorial campaign to damage Director Patel's reputation and force him from office. The Atlantic reported that Director Patel was on the chopping block, signaling an editorial predisposition to cast his tenure as failing. So-called journalist Fitzpatrick and her colleague Ashley Parker authored an article predicting Director Patel's imminent firing from his position. On April 2nd, they authored an article about him about to be fired. And then they cited their own article in the April 17th hit piece. That's the basis for this defamation suit. They cite their own article, self-referentially reinforcing the Atlantic's preformed narrative. The Atlantic's conduct towards Patel is part of a broader, well-documented pattern. Numerous Atlantic pieces over the past 2 years have characterized Patel as unqualified, dangerous, corrupt, or mentally unstable. Then we get to the defamatory article. I see we got a super chat here. Let me take a look at this quickly. Germanicus says, "You filled my Scott Adams slot." That is high praise. Thank you. Thanks for the great commentary. We are going to win. Well, Scott Adams is big shoes. By the way, did you know Scott Adams had me blocked on social media? He, you may know when COVID hit, Scott Adams had a meltdown over COVID, which I found really surprising because Scott Adams' brand, and I own all the Scott Adams books. Of course, I'm a fan of Dilbert. I got a lot of respect for Scott Adams, but he's one of these guys who was super smart and then had these weird intellectual gaps. He's very rational, very objective, and but when COVID hit, he just panicked. I think he might have had a little bit of hypochondria. It felt like that, the way his response to COVID. And so I wrote him on social media. I said, "Scott, what are you doing? You're the rational guy. You're the objective guy, and you're breaking down in panic over this virus it's not even a bad cold for people who are otherwise healthy, who don't have some particular vulnerability like they would have to seasonal flu." And he blocked me. He didn't like that. But I have a lot of admiration for Scott Adams. He certainly missed. It was a great loss. Let's see. Did I get it? I got it. All right, super chats. Back to work. The defamatory article. On April 17th at approximately 6:20 p.m. Eastern Time, defendants published an article in The Atlantic, originally headlined, "Kash Patel's erratic behavior could cost him his job," with the subheadline, "The FBI director has alarmed colleagues with episodes of excessive drinking and unexplained absences." By the way, if these were true, that would be a problem, right? We don't want an FBI director who's engaged in excessive drinking and unexplained absences. There'd be good reason to be concerned. The article's very headline telegraphed its intended outcome. It was not journalism about a subject. It was advocacy against Director Patel. Defendants made no effort to disguise their aim. The article was widely disseminated on the internet, through the magazine, associated platforms, foreseeably republished, summarized, discussed through national and international media. All right, here we get to the meat of it. The article included numerous false and defamatory statements of fact concerning Director Patel, including, but not limited to, A, Director Patel is known to drink to the point of obvious intoxication, in many cases at the private club Ned's in Washington, D.C., while in the presence of White House and other administrative staff. No name source, no email, no photograph, no nothing. B, Director Patel is also known to drink to excess at the Poodle Room in Las Vegas. I have to confess, I've been to Las Vegas many times. I've never heard of the Poodle Room. I'm not sure I would go to a place called the Poodle Room, but nevertheless, where he frequently spends parts of his weekends. Again, not a single photograph, nothing in The Atlantic about this. That early in Patel's tenure, meetings and briefings had to be rescheduled for later in the day as a result of his alcohol-fueled nights. Evidence of this? D, that on multiple occasions in the past year, members of a security detail had difficulty waking Patel because he was seemingly intoxicated. Seemingly. According to information supplied to Justice Department and White House officials. Like who? E, that a request for breaching equipment, normally used by SWAT and hostage rescue teams to quickly gain entry into buildings, was made last year because Patel had been unreachable behind a locked door. Where's the evidence of this? Because this kind of breaching equipment, it has to be logged out. If it was requested, there'd be a record of it. F, that Director Patel's alleged alcohol consumption has negatively impacted various law enforcement investigations, including the Charlie Kirk murder investigation. G, that Director Patel recently expressed frustration with the look of FBI merchandise, complaining that it wasn't intimidating enough. Well, what's wrong with that? What's wrong with that? By the way, there's the official FBI gift shop. I don't know if there's one in the Hoover building in D.C. I've never been inside the Hoover building, but I've been to the FBI Academy at Quantico a number of times. I've taught there, as I've mentioned before, and they have a little gift shop in there. You can buy like an FBI sweatshirt and ball cap and coffee mug and all the usual stuff you see in a gift shop. And yeah, I bought some when I go there. I've got my FBI sweatshirt around here someplace. It's perfectly ordinary, but maybe Director of the FBI has an opinion about what's in the gift shop. H, that on April 10th, 2026, Director Patel panicked frantically, calling his aides and allies to announce he had been fired by the White House and that his behavior was a quote-unquote freak out. I, that Director Patel is often away or unreachable, delaying time-sensitive decisions needed to advance investigations, and that on several occasions, Director Patel's delays resulted in normally unflappable agents losing their shit. You think Patel should be accessible on a moment's notice to every special agent in the FBI? You think any director of the FBI operates that way? Director Patel's drinking, J. Director Patel's drinking has been a recurring source of concern. Well, what are people concerned about? Concerned about reality or concerned about false rumors? K, the false implication that Patel violated DOJ ethics rules prohibiting habitually using alcohol or other intoxicants to excess. L, that Patel has used his position to improperly target political or personal adversaries of the president. M, the false implication that Patel abuses alcohol, thereby making him vulnerable to exploitation or coercion by foreign adversaries. N, the false implication that this alleged alcohol abuse has become a threat to public safety, including in the context of a domestic terrorist attack, and constitutes a national security vulnerability. O, that Patel is deeply concerned that his job is in jeopardy. Why would that be a problem? Even if it were true. P, that Patel has a problem with unexplained absences and spotty attendance at the office, thereby falsely implying that Director Patel has been derelict in his duties. You think the director of the FBI gets to come and go as he pleases, gets to allocate his time and locations as he wishes? Who else would he be answerable to? Just the Attorney General of the United States? Is she complaining? And above her, Trump. Q, that Director Patel left the country vulnerable because days before the U.S. launched its war with Iran, Patel fired members of a counterintelligence squad that was devoted in part to Iran. Each of the foregoing statements and implications is false. They are so demonstrably and obviously false or easily refuted that it was at best reckless to publish them. And of course, reckless disregard for the truth satisfies the actual malice standard. Now again, this statement is a statement of fact, claimed fact, right? Could be disproven by other evidence, but it's a claimed fact in this complaint. If the Atlantic were to file a motion for summary dismissal prior to discovery starting, the judge is supposed to make that legal determination, should this be dismissed, by having to presume that every fact alleged in this complaint is true. Only Even if they're true, there still would not be a basis for the suit. Can it be dismissed at a preliminary stage? So every fact in this complaint has to be presumed to be true on a motion for summary dismissal. The complaint continues. Check for super chats as long as I paused. Okay, the complaint continues. The article's assertion that Director Patel drinks to the point of obvious intoxication at Ned's in Washington, D.C., and to excess at the Poodle Room in Las Vegas, and that his drinking has been a recurring source of concern across the government are false. Director Patel does not drink to excess at these establishments or anywhere else. And this has not and has never been a source of concern across the government. Prior to publication, the FBI expressly informed defendants that each of these allegations was totally false. That was a subordinate of Patel's who sent that notice to the Atlantic. The FBI further warned defendants that these allegations echoed a similar fabrication previously aired by MSNBC's Frank Figliuzzi on Morning Joe, anonymously sourced reporting that was later retracted by MSNBC, and that is the subject of pending defamation litigation, yet defendants published it anyway. So this would be reason for the Atlantic to know that there's evidence that supports contrary, that the statements they're about to publish are not true. The article's claims that early in Director Patel's tenure, meetings and briefings were rescheduled due to alcohol-fueled nights, that members of his security detail had difficulty waking him because he was seemingly intoxicated, and that a request for breaching equipment was made because he'd been unreachable behind locked doors are false. None of these events occurred. Prior to publication, the FBI expressly informed defendants that these claims were totally false, made up to the point of satire. As is standard protocol, easily verified, and would have been known by any credible FBI source, breach equipment is provided to all FBI protection details. The claim that it was requested or provided to Director Patel's detail because he'd been unreachable behind locked doors is pure fantasy. The article's assertions and implications that Director Patel's alleged alcohol consumption negatively impacted law enforcement investigations, including the Charlie Kirk murder investigation, violated DOJ ethics rules against habitual intoxicant use, rendered him vulnerable to foreign adversary coercion, and constituted a threat to public safety and national security, including in the context of a domestic terrorist attack, are false. Prior to publication, the FBI expressly informed defendants that these claims were 100% false, and that under Director Patel's leadership, the FBI had just delivered its most successful year in decades, with a historic drop in violent crime, a 20% drop in the national murder rate, a 31% increase in fentanyl seizures, and the successful disruption of multiple terror plots. The article's assertions that on April 10th, Director Patel panicked frantically, announcing he'd been fired, engaged in a freakout, and is deeply concerned that his job is in jeopardy are false. On April 10th, Director Patel had a routine technical problem logging into a government system, which was quickly fixed. Patel's sole focus is on carrying out the administration's law enforcement priorities. Prior to publication, the FBI expressly informed defendants that the firing rumor was a made-up rumor and that the freakout and job jeopardy claims were fabricated. The article's assertion that Director Patel is often away or unreachable, causing delays that made agents lose their shit, and that he has unexplained absences and spotty attendance at the office are false. Director Patel is at FBI headquarters nearly every single day, and when he is not at headquarters, he is visiting field offices, which he has done more frequently than any of his predecessors. A fact independently verifiable through his public social media account that defendants were specifically directed to review. Prior to publication, the FBI expressly informed defendants that these claims were completely made up and divorced from reality. And when pressed to identify any officials, instances, or absences supporting the claims, defendants offered none. The article's assertions that Director Patel had used his position to target political and personal adversaries of the president, that he complained the FBI merchandise isn't intimidating enough, and that days before the U.S. launched its war with Iran, he fired members of a counterintelligence squad that was devoted in part to Iran, leaving the country vulnerable, are each false. Director Patel has not targeted political or personal adversaries. FBI personnel actions are taken only when employees have acted unethically or undermined the mission. Now, what's being referred to here, of course, is that the FBI has fired a bunch of agencies who the FBI, under Patel, believe engaged in misconduct in going after Trump in previous years. The FBI would say that's an appropriate termination. Continuing here, his security detail confirmed that he has made no such complaint about FBI merchandise. And the squad referenced was within counterterrorism, not a dedicated Iran counterintelligence squad, with only 3 affected individuals even tangentially working on Iran-related matters. Prior to publication, the FBI expressly informed defendants that each of these statements was false, including the merchandise claim was absolutely false, and the Iran squad claim is not true. Furthermore, Director Patel has taken significantly fewer personal days than either of his 2 immediate predecessors, Wray or Comey. In calendar year 2025, Director Patel took approximately 17 personal days, fewer than Director Wray averaged in any single year of his 7.5-year tenure, during which Wray accumulated roughly 242 personal days, including 37 in 2024 alone, 31 in 2023, 33 in 2022. Director Comey likewise took approximately 130 personal days over his 4-year tenure, including 63 in 2014, 2 full months, 42 in 2015, 5 weeks, when he routinely traveled home to New York every weekend or every other weekend. Put simply, Director Patel's personal day usage in 2025 is less than half of Wray's yearly average and a small fraction of Comey's peak years. Even after stealth editing their headline over the weekend in a feeble attempt. Is that how you spell feeble? That's not how you spell feeble. Feeble is 2 E's, right? Yes, feeble is 2 E's. Shame, for shame. Even after stealth editing their headline over the weekend in a feeble attempt to produce the appearance of partisan animus, defendants have doubled down on their knowingly false claims on an X post made this very morning. So that would be yesterday. That reads, quote, Kash Patel's colleagues are alarmed by what they say is erratic behavior and excessive drinking. Sarah Fitzpatrick reports. I shared that with you, right? That's this. Well, it's too hard to pull up and StreamYard like this. More than 24 people she spoke with described his management failures and conduct that could harm national security. Again, she doesn't say these 24 people talked about erratic behavior or excessive drinking. I wonder why. As discussed above, these claims about erratic behavior and excessive drinking are fabricated, and defendants were on notice of this. Goes to reckless disregard. Fitzpatrick knows that her anonymous sources, unwilling to go on the record, are partisans with axes to grind and not in a position to know the facts. And we got a Rumble rant here from my admin. So let me pull that up. Let's see. Here it is. B-Job Secure, who's my admin over on Rumble, writes, posted by Dog Decker in chat, very interesting, sir, the Poodle Room. The Poodle Room. All right, there's a link to the Poodle Room. I'm gonna save that. I'll address it at the end for all of you who stay with me to the end. The Poodle Room. I have to accept cookies. Yeah, okay. I'll come back to that. Thanks, man. I appreciate that. That's a good link. All right, back to the complaint. Whoops. Defendant's conduct exhibits actual malice. again, actual malice is the big barrier here, legal barrier. And then, of course, there's the political hurdles in D.C. Defendant's quote-unquote investigation of the claims in the article was grossly deficient and deliberately so. They did not pursue obvious investigative leads, did not engage with publicly available counter evidence, even evidence that was directly provided to them, did not afford a reasonable opportunity to respond, and did not conduct the most basic fact-checking that a responsible publication undertakes before attempting to destroy a public official's reputation, even after the FBI explained to defendants on the record that their claims were false. Defendants ignored their own, this must be policies, and procedures, rushing the story to print without substantively fact-checking the allegations or giving Patel a meaningful opportunity to respond, all to publish before the truth could be exposed and derail the article. On April 17th, 2:09 p.m. Eastern Time, the same day of publication, The Atlantic transmitted to the FBI Office of Public Affairs a purported request for comment containing 19 substantive claims about Director Patel. Atlantic imposed an arbitrary and unreasonable deadline of 4 p.m. Eastern Time, less than 2 hours, for the FBI to respond to 19 detailed allegations concerning complex issues of national security personnel files, security detail logs, internal facilities logs, and personal conduct. The 2-hour window was pretextual. No reasonable journalist investigating such serious charges involving alleged need for a SWAT-style breach of the director's office, alleged alcohol abuse by the head of the nation's preeminent law enforcement agency, alleged falsehood about an active homicide investigation, and alleged national security compromise would have demanded a substantive response within 111 minutes. Defendants imposed that window precisely to manufacture a no comment or a summary denial, to insulate themselves from the substance of the FBI response and to publish before the truth could catch up with them. FBI Public Affairs responded before publication that AMG's claims were one of the most absurd things I've ever read, completely false at nearly 100% clip. Defendants buried this striking language, never reported it, and chose to publish the claims anyway. They included only a generic, truncated denial attributed to Director Patel. Quote, "Print it all false, I'll see you in court, bring your checkbook." The FBI also, as illustrated above, provided substantive refutations of defendants' claims, which defendants entirely ignored. Also on April 17th, prior to publication, Patel's counsel sent Fitzpatrick, AMG's legal department, and Atlantic senior editors a detailed letter, the pre-publication letter, further refuting AMG's false claims on the record, providing publicly available counter evidence, and demanding that Atlantic not publish them, presumably meaning the lies. This was obviously put together on a tight deadline. The pre-publication letter expressly requested that defendants afford Patel and the FBI a full and reasonable opportunity to respond to the 19 allegations, necessarily requiring additional time beyond the arbitrary 2-hour window defendants imposed, but they refused. They did not extend the deadline. They did not even respond to the letter. They did not acknowledge the publicly available counter evidence. They did not retract or modify the false statements identified. They made no meaningful response at all. They simply ignored the letter and published the false claims a few hours later. Defendants' conscious decision to ignore the detailed, specific, and substantive refutations in the pre-publication letter and their refusal to give a reasonable amount of time for the FBI and Director Patel to respond is among the strongest possible evidence of actual malice. A reporter or publisher genuinely concerned with accuracy does not brush aside a detailed, on-the-record refutation from counsel identifying specific falsehoods and offering counter evidence, does not refuse a good faith request for additional response time on 19 complex allegations, and does not publish anyway, unchanged, hours later. In addition to the FBI's public affairs pre-publication denial, defendants received on-the-record statements from senior administration officials that contradicted the article's core premise. White House Press Secretary Carolyn Leavitt told defendants that under President Trump and Director Patel, crime across the country has plummeted to the lowest levels in more than 100 years, and many high-profile criminals have been put behind bars. Again, that's kind of that generic statistic. I'm not sure is really a reflection of the FBI, but of course they have done other stuff. That is to their credit. And that Director Patel remains a critical player on the administration's law and order team. Acting Attorney General Todd Blanche, who stepped in on an acting basis after Pam Bondi was fired as Attorney General, told defendants that Patel has accomplished more in 14 months than the previous administration did in 4 years, and that anonymously sourced hit pieces do not constitute journalism. Defendants included these statements in the article only to brush them aside. They made no effort to reconcile these on-the-record denials, backed by documented, publicly reported law enforcement successes, with the article's central thesis that Patel is a derelict, an erratic leader who abuses alcohol to the point of being unfit for his duties. Defendants also ignored or willfully avoided an extensive public record directly contradicting their narrative. A responsible reporter, a competent editor, or a non-reckless, absence of malice, fact checker would have taken notice of, among other things, the following. The FBI's extensive, contemporaneous, and publicly documented operational output under Director Patel about all their successes. Director Patel's robust public schedule and visible, documented presence at FBI headquarters, field offices, joint operations, press conferences, congressional appearances, and on-the-ground deployments, all of which are documented in FBI public communications, photographs, video, and contemporaneous press coverage. Defendants claim that Director Patel is often away or unreachable, could have been tested against, and would have been refuted by the public record of his appearances and activities. They ignored Director Patel's congressional testimony and briefings, which are publicly recorded, and which depict a director who's engaged, substantively prepared, and actively directing bureau operations. They ignored the absence of any corroborating public record for the sensational breaching equipment claim. No internal incident report, no SWAT deployment record, no news report, no photograph, no complaint. A single call to any knowledgeable source inside the Bureau's Security Division or simple Freedom of Information Act inquiry would have easily exposed the fabricated nature of the claim. They ignored the publicly available history of prior, substantially similar false claims that were publicly rebutted by Assistant Director Williamson and that are the subject of active defamation litigation filed by Director Patel. Defendants either knew or should have known, that's the reckless component, that the sources recycling these tropes lacked credibility. Stephen Frazier with $10. Thank you very much, my friend. Always generous, Stephen is. On a roll today. Well, thank you, my friend. I try to deliver for all of you. All of you. Is no one hitting the subscribe button? The number hasn't changed. The number on the odometer has not changed. How many of you are here? Over 600 of you on YouTube alone. I know not all of you have already subscribed. Hit that subscribe button. Hit that thumbs up like button. Do it now before you forget. The complaint continues. A minimally competent journalist investigating allegations this serious would have taken several basic, obvious steps before publication, and defendants took none of them. They never reviewed FBI security detail protocols that would have shown the waking the director story was operationally implausible. They never asked for any documentation of the supposed need to breach the director's office, even though such an incident would have generated multiple written records. They never contacted Ned's in D.C. or the Poodle Room in Las Vegas for corroboration, nor sought credit card records, photographs, or witness statements. They never cross-checked Patel's public schedule against the claims that meetings had to be rescheduled for alcohol-fueled nights. They made no serious effort to determine whether their anonymous sources had been disciplined or removed by Director Patel, and therefore had obvious motives to lie. They refused a reasonable request for additional time to respond to 19 detailed, albeit ridiculous, allegations. They ignored a detailed pre-publication letter from counsel identifying specific falsehoods and supplying counter evidence. And they never interviewed Director Patel himself or gave him any meaningful opportunity to address the charges in his own words. This is not negligence, which would not be enough for malice in a defamation claim by a public figure. It demonstrates a deliberate and malicious smear. The vast majority of the defamatory claims in the article rely solely on vague, unattributed sourcing, such as, quote, people familiar with the matter, and, quote, some have characterized, and, quote, officials said, and, quote, former advisors, and similar formulations. Any such purported sources could not possibly possess firsthand knowledge of the events described, both because the sources were not in a position to know and because the events described did not occur. Defendants' complete and total reliance on these anonymous sources. Defendants could not get a single person to go on the record, nor could they cite a single email or piece of documentary evidence. For such breathtaking and scurrilous allegations, once again, is not mere negligence. It demonstrates a deliberate and malicious smear. The article itself reveals that defendants understood their sources were animated by hostility. Defendants relied on former advisors and political operatives, categories of sources with obvious axes to grind. Defendant Fitzpatrick knew this. As to the allegedly current officials cited in the article, their animus towards Director Patel is readily apparent and known to Fitzpatrick, stating that such officials have learned to roll their eyes at Patel's actions, and one official going so far as to say, part of me is glad he's wasting his time on bullshit because it's less dangerous for the rule of law, for the American people. Also known to Fitzpatrick was that both the former and allegedly current sources lacked any legitimate access to specific operational, security, and personal facts they purported to describe. Contrary to these anonymous, nescient, and obviously axe-grinding sources, official representatives of the FBI, DOJ, White House all emphatically denied defendants' allegations on the record. Further, in May 2025, a former FBI official made a suspiciously similar claim about Patel on MSNBC's Morning Joe. That anonymously sourced claim that Patel had been visible at nightclubs for far more than he's been on the 7th floor of the Hoover building, which is the top floor, it's where the big bosses are, resulted in active, ongoing defamation litigation filed by Patel in the U.S. District Court for the Southern District of Texas, where he might have better luck than in D.C. Assistant Director Williamson has publicly rebutted that claim and others like it, and MSNBC itself acknowledged the claim was a misstatement that had not been verified. Defendants were aware of both the prior false statements and Director Patel's vigorous public and legal refutation of them. The parallel between the article's, quote, drink to excess at the Poodle Room in Las Vegas narrative and the defamatory Morning Joe claim is unmistakable. Despite this, defendants chose to publish a similar and even more outlandish set of false allegations, plainly drawing on the same currents of rumor that had already been publicly discredited and were in litigation. The fact that defendants elected to republish in different form claims that had already been debunked and were in active litigation is additional evidence that defendants either knew their claims were false or acted with reckless disregard for the truth, the legal standard for actual malice. The totality of these circumstances reflects a purposeful avoidance of the truth, actual malice. Defendants did not simply fail to check facts. They received a detailed pre-publication letter and emails identifying those facts and ignored it. They received a request for additional time to respond and denied it. They received a categorical denial from the FBI and buried it. They deliberately structured their pre-publication process to avoid facts that would have contradicted their narrative and then publish that narrative in defiance of the facts they could not avoid. The article has been republished, summarized, and discussed in countless other media outlets, multiplying the harm to Director Patel exponentially. Causes of action. Count one, defamation and defamation per se. So when you sue for defamation, a part of that is then you have to show damages. You have to sue for damages. But there are some lies that are inherently damaging, like if you accuse someone of a vile crime, and then you don't have to prove damages, at least up front. And that's defamation per se. Let's see. Plaintiffs incorporate everything we just read. Defendants publish these statements to third parties by publishing them in the Atlantic. So publication is a requirement of defamation. If you're just thinking bad things about someone, that's not defamation. You have to put them out in the world. You have to publish them. So they're just checking that box. The statements are false, of course. To be defamatory, the statements have to be false. That's another element of a defamation claim. They are defamation per se because their defamatory meaning is obvious on their face. So that goes to the damages question. Defendants publish these statements with actual malice. So that addresses the actual malice requirement because of Patel's status as a public figure. And I'm not going to recount all this because we just read it. They published the statements knowingly, intentionally, willfully, wantonly, maliciously, with intent to harm Patel, or in blatant disregard, and this goes again to actual malice. Defendants have caused actual damages, including harm to reputation, and these damages were foreseeable. Patel is entitled to compensatory, special, and punitive damages in an amount not less than $250 million, as well as disgorgement of all income defendants have earned by virtue of their lies about Patel. Prayer for relief, this is what they're asking for. They're asking for the $250,000 and whatever other relief the court is inclined to provide, which is a normal way of phrasing all this. All right, so that is the lawsuit over the Atlantic article on Kash Patel. He's a drunk, he's incapable, he's a threat to national security, and all that stuff. I'm beginning to get a little concerned about this subscriber odometer. Maybe I should refresh it. It has not gone up even by 1 in an hour and 13 minutes of show. Someone tell me, has someone clicked on the subscribe button? Should it have changed? I just want to make sure something's not broken. Let me know in the comments. And meanwhile, I'll take a look at the Poodle Room. This is the link that was sent to me. The Poodle Room. Oh, the Fountain Blue. Fountain Blue. That's the Fountain Blue is a relatively new hotel casino in Las Vegas. Just opened up a couple years ago. I can see in the background there. It looks like that's probably the above the chair on the right. That's the Encore, which is a nice hotel. That's where I typically stay when I go to Vegas. The Encore. When I stay with my wife, I go to the Encore. Or the Wynn. Those are my two favorite hotels in Vegas. When I go with friends, we usually stay at we've stayed at the Encore before, but usually we stay at Crockford's Resort World, which is very close nearby, of course. So the Poodle Room, I've never heard of it, but it would be new in the Fountain Blue. The Poodle Room is an exclusive members-only lifestyle and social club crowning the 67-story hotel tower of Fountain Blue, Las Vegas, inspired by legacy and a commitment to bespoke, once-in-a-lifetime experiences. The club reflects the iconic destination first established in the 1950s at the Fountain Blue, Miami Beach. So what do you get? You get more than a view. As a member, you gain access to exclusive events, private tastings, curated entertainment, priority reservations, a private escape, concierge at your service. Who can access? Private members only venue. What's included? Dedicated poodle room, concierge for dining, spa, and entertainment. Invitation to members only events. Exclusive access to reserve for new, the Red Room. Some other stuff, amenities. Poodle Room offers a refined and relaxed setting featuring a cigar lounge, specialty cocktails, elevated light bites, and a signature dessert cart. The space includes a den for larger gatherings and an open-air garden terrace. Is there a dress code? Yes. Dress with intention. So, what do they charge? Does it say what they charge? Let me look at the application form. Apply now. Let's see. Probably if you have to ask how much it costs, you can't afford it. Is it that kind of thing? Let's see. Membership application. Occupation. Profile photo. Individual membership or a significant other membership. Not spouse. That's it. They don't tell you what the fee is. Does it say? Was it in the FAQ? No. No, I guess if you have to ask, you can't afford it. It's a nice view. Anyway, right down the strip. You're looking right down the strip. This is almost the end of the strip here. All right, so let's see. Let me look at the chat. Looks like a tilapia kind of place. They do have a nice pool. I did visit there to take a look at it, and the pool was nice. Let's see. Regine Reynolds says, that's what I figured Cash would be going for is the cigar lounge. I don't know. Dog Digger says, Andrew, you know Vegas much more than I do. I go there at least once a year, either for work or to meet up with friends. But I don't gamble. I will say this: Vegas has some nice restaurants. They have some good food there. I do appreciate that, and it has some nice hotels. It has some not nice hotels too. There are definitely some not nice hotels, and it's the nice hotels are expensive. The Wynn and the Encore are expensive, no question about it. I did recently go to, gosh, what the heck is it called? The one with all the pools. There's one that has pools that are good for kids. What the hell is the name of it? I'm surprised it's not coming right up. It's right by the Luxor. It's a pair of buildings. Mandalay Bay. I did go there recently because I heard it had a lot of pools that were good for kids. I brought the kids, and I don't think I would go back to Mandalay Bay. Yeah, Vegas is kind of crazy in terms of cost these days. They upcharge you for everything. Everything's expensive. So when I brought the kids and my wife, so the kids had never been to Las Vegas. As soon as we get in the room, there's like a tray. The tray has got, very costly snacks, right? $20 M&Ms, $20 bottles of water. And if you touch them, the tray is pressure sensitive. So if you touch them, even if you don't consume them, if you touch them, you get charged for it. And of course, my kids got in there. They see all these snacks and candies, and they're grabbing them to look at them. I had to go right down to the front desk and get all those charges reversed. But if I hadn't noticed, they all would have been on my bill when I checked out. So you do have to be careful there. All right. Well, I don't know that we have. I think we're all set. I think we're all set. Did anybody hit the subscribe button? I'm gonna look in the comments and see. Yeah, there's no nice deals in Vegas like there used to be in the 1990s. In the 1990s, they would Vegas figured they made their money on gambling, and everything else was relatively inexpensive. So if you didn't gamble, it was a pretty good deal. But now they've just chosen a different business model. Their clientele is now high wealth individuals, and they don't care about anybody else. Somebody here says, Texas 47 says it's a $5,000 annual membership. $5,000 to be in a bar. All right, guys, I think it's time to transition over from this open access show, which is where we've been spending our time right here, to the members only show. We're going to talk about the Department of Justice. My buddy Bill Shipley wrote a Substack on his experience at the DOJ as a federal prosecutor and describing how the DOJ became politically captive by the progressive fascist left in America. That's what I wanted to share with all of you. Hey, we got a new member. Welcome aboard. You'll be able to join us for the member only show. It's only 16 cents a day, folks. $5 a month to be a member of this channel. Links for membership and links for the member only show are all in the description. And I'm gonna launch that right now. So that'll go live even as we're signing out of this one. Let me start the background music. All right, the members only show is going live right now on YouTube and on Locals. You can be a member on Locals too. Same deal, 16 cents a day, $5 a month. I'll see you all over there in just a moment. And until I see you there, I remain Attorney Andrew Branca for The Branca Show. Stay safe.